What's up, everybody, and welcome back into another video covering Chad Daybell's trial. And in today's video, we're going to talk about whether or not Chad Daybell is going to testify in his own defense, and if we think he made the right decision. We'll talk about the rest of the defense's case in chief and the beginning of the state's rebuttal, and most importantly, what's next and when we expect this case to actually end. It's been weeks and weeks and weeks. Are we getting close? Plus, we'll answer your questions, look at your comments, and discuss what you want to talk about and what you've asked in other videos, all that and more on today's video. So hit that like button if you guys haven't already, and make sure you subscribe to our page. We are going to start with one of your most asked questions. Will Chad Daybell testify in his own defense? Most defendants don't. Lori Vallow didn't. But many of you thought Chad Daybell was a narcissist and thought he could talk his way out of this. And from my perspective, the way I look at it is, can a criminal defendant help their case or hurt their case by testifying? Obviously, usually it's, yes to both questions. But you really have to focus on what his defense is. And Chad Daybell's defense is he was manipulated. Lori Vallow manipulated him with her looks and her beauty and all of that. And Alex Cox was doing things with Lori Vallow to the kids and otherwise that he was not aware of, and he didn't know what was going on. Lori told him the kids were safe, and he just basically followed her lead, and he didn't do anything to Tammy, and Tammy died of natural causes. That's basically his defense. So does he need to testify to solidify that? That's the big question in our minds. And before I give my opinion on what I think he should do, let's take a listen to what he decides to do and whether or not we agree with it.
These proceedings. After sidebar with counsel, the court's been advised that at this point, the defense does not intend to call any further witnesses. So I guess the remaining issue or question to address would be whether or not the defendant's going to testify. Mr. Pryor, is that the status of where things stand with the defense case in chief?
Yes, Your Honor.
Okay. Mr. Daybell, I will instruct you that there is going to be a jury instruction in this case the court's going to give. It states, and I'm paraphrasing, that you do have a constitutional right not to be compelled to testify. The instruction will say the decision whether to testify is left to the defendant acting with the advice and assistance of the defendant's lawyer. The jury will be instructed not to draw any inference of guilt from the fact the defendant does not testify, and the jury will be instructed not to discuss or enter into deliberations the issue of the defendant chooses not to testify. If, in fact, you are going to testify, then, Mr. Daybell, there's a further admonishment or advisement I would give you going forward. So let me begin with Mr. Pryor and just first just inquire whether or not you have discussed with your client whether or not he intends to testify.
I have discussed that matter with Mr. Daybell, Your Honor.
All right. And does he intend to offer testimony in this trial?
He does not.
All right. Mr. Daybell, have you, in fact, discussed that issue with your attorney?
Yes,
And has he advised you of your right to either testify or not be compelled to testify in this trial?
he has.
All right. And it's your decision to not testify. Is that correct?
That is correct.
Okay. Thank you, counsel. I appreciate you clarifying that with the court outside the presence of the jury. So with that, then, we'll take our morning recess, and I will ask the defense then in the presence of the jury if they rest their case. And again, the court will provide the instruction to the jurors that they may not consider the decision of the defendant not to testify in their deliberations with that instruction that will be provided. So we'll take the mid-morning recess, and let's come back on the record in about 15 or 20 minutes. And
So we finally hear from Chad Daybell. We hear his voice. Seems like he understands what's going on. To me, it almost looks and seems like a guy resigned to the fact that he knows he's going to lose and spend the rest of his life in prison. That's just what it looks like to me with his demeanor. I'm just reading into that, and that's one man's opinion, and I am not an expert on any of that as far as body language goes or anything. But sitting in that chair next to people that are in criminal cases, and sometimes they know that they're going to lose, sometimes they're confident they're going to win, sometimes they know they're going to win, and sometimes they're right, sometimes they're wrong. That's my opinion on how he looks. So he's not going to testify, and the judge is going to instruct the jury that they cannot hold that against him. Just about every single juror I've ever spoken to or listened to an interview of says, we did want to hear from the defendant, even if they say something like, but we realize that it's his right and we don't hold it against him, but they almost always want to hear from the defendant. And you have to take that into account, but it's not the overall determining factor. So he decides not to testify. Do I agree with that decision or not is a question so many of you guys have had. In my opinion, Chad Daybell is making the right decision in this case. I don't think there's anything he's going to say that's going to overcome anything the jurors believe at this point if they believe he is guilty and they believe the state has proven their case beyond a reasonable doubt. But also on the flip side, if they believe Pryor's angles, that first off, their best argument, which I still think is a loser, but their best argument that Tammy Daybell died of natural causes. And the only reason this was opened back up is because of all the stuff that happened with Lori Vallow, and they just wanted to pile on with these extra charges. And but for all that other, added context or other circumstances, they never would have looked into this again. There were bruises that were non-specific. There was no real explanation for her death. So they came up with asphyxia, which is a diagnosis by exclusion. And it could have been, and it's possible that it was other things as well. We have a coroner that says it wasn't, or it was natural causes. We have a defense expert that says there's no real reason to prove her cause of death. Therefore, it's unspecified, and they would not rule it a homicide. But we have state medical experts that would say it was a homicide by asphyxia. And they give all the different ways it could have possibly happened. From my perspective, I think the state's evidence is stronger, personally, to prove that beyond a reasonable doubt. And the context of what he did and how he acted afterwards is important circumstantially to prove that case. Will the jury believe that? I don't know. But my point in that long diatribe is nothing Chad Daybell is going to say about that, in my opinion, is going to fix any of his problems. It's not going to prove it to the jury. Whether he was awake, whether he wasn't, whether she went upstairs or downstairs, whether it was this time or the other, whether she was this cold or her lips were blue or not, nothing he's going to say, in my opinion, is going to change the evidence they've heard to make that decision. Number two, the angle of Lori Vallow being the manipulator and the manipulated one. Chad Daybell has already had witnesses that have stated they were saying light and dark scale, or other people saying other people had light and dark scale in addition to Chad. Chad wasn't the only one doing that. They were all in this together. They all discussed this stuff together. Other people saying Lori is manipulative. Now there's people saying Chad's manipulative, but the jury's already gotten both sides of the story and both sides of the coin, and they have to determine credibility and who they believe. So could Chad Daybell get up there and convince them he's not the manipulator? In order to do that, some may see him as manipulative. So it's a risk. And I actually think there wasn't a lot of benefit for him to come and testify. So I do think he made the right decision. Will it end up winning the day for him? I don't think so, but only time will tell as we wait for a jury verdict. So then the defense rests their case after what I thought was some not very compelling expert testimony. I don't really want to get into it too much about, burning of the bodies and DNA and things like that. I don't think it proved much as far as the main and most effective potential defenses Chad Daybell and John Pryor, which I've mentioned multiple times in this video already, have put forth for this jury to consider. So then the state wanted to bring rebuttal witnesses, but there was a major issue. And we've talked about what happens if these witnesses are released and they're no longer under the rule of sequestration. What happens if the state wants to call them again? And I said, if they violate the rule, I don't think they can be called again, but I don't know if there are certain ones they're keeping under subpoena and telling them to still stick by the rule. If they're experts, obviously they can still watch the trial. We've heard the judge say that multiple times. Well, this exact issue came up, and it's from a law enforcement officer that I think the state could have tried to maybe argue as some kind of expert, but it wouldn't have really mattered, especially for what he was coming to testify about. But let's listen to some of these arguments and just a little bit of the background. This officer was going to come testify that Mr. Murray, Daybell's son-in-law, basically called him a liar, and he wanted to come and say, no, what I said was the truth. And whether or not that's appropriate rebuttal, whether or not he's tainted because of what he's already watched of the trial, how the state handled it, how the defense argues, and eventually how the judge rules. Pretty interesting legal back and forth here that we're going to watch that a lot of you had questions about right before the weekend. It is the weekend, by the way. Happy weekend, everybody. Happy Saturday, long weekend. It's nice to kind of chill and relax and not watch a trial and, just watch basically a half day of this, and had some thoughts on it. And you guys had some questions. So I figured I'd drop a video for those of you that are missing watching trials over the weekend, to get a little taste of what's happened in this case as it's winding down, and what's going to happen next, because that's one of the other most common questions as I've read through the comments on the other videos in this trial. So let's listen to this back and forth and this interesting legal argument of what happens when they try to call a witness in rebuttal that hasn't been under the rule of sequestration anymore.
Which is simply that never happened. Now, going to the taint issue, I should further tell on a computer screen had been relayed or shown to Deputy Cannon. Deputy Cannon heard that, and Buchanan contacted our office immediately and wanted to come set the record straight. Well,
so this deputy was watching the trial, heard Mr. Murray's testimony, contacted their office, and wants to set the record straight. That's how we got here. That's why the state wants to call him as a rebuttal witness.
He just heard testimony, so we saw that as an issue. I think we may have even approached that off the record of the court. We didn't call him back in our case in chief. But now the defense has put on this evidence, and on the first point, if the court might recall, and again, I don't want to mischaracterize how his testimony came in, but when I was cross-examining Joe Murray on the point about whether or not Joe had heard Tammy scream and had been outside, I had even opined, leaving the door open directly in my questioning, to the fact that Deputy Cannon may simply have misheard or got something wrong as a mistake. And the witness was very adamant that he did not accept that as reality. He thought it was intentionally inaccurate information. So effectively, Deputy Cannon, his character has been attacked. He's been called a liar in front of the jury. So he wishes, and I think understandably so, whether that's a big factor for this court, he wishes to be able to come and to offer what he believes is the truth, which is simply that never happened. Now, going to the Tain issue, I should further tell Your Honor that when he contacted us after his testimony, we instructed him to stop watching the trial and listening, and he did. After so much time passed, and then our case rested, he began listening again, and he listened to Garth Daybell's testimony as well as Joe Murray's. So I need to disclose that.
So it's like they told him, hold on, we might be calling you. And then when they rested their case, they're like, all right, never mind, we're not going to recall you. And then he heard the defense's case, and he's like, well, hold on. He contacts them, and they're like, okay, now we actually do want to call you. So a bit of a mistake by the state. If they thought there was any possibility of calling this guy, you have to keep him under the rule. But a major problem is it doesn't sound like they would have recalled him had he not watched and listened to the testimony like he wasn't supposed to if he was going to be called as a witness. But because, and I don't want to say he violated the rule because he wasn't under the rule anymore, but because he did what you're not supposed to do if you're under the rule of sequestration, that's what made him a relevant witness again for rebuttal, which is not how it's supposed to work. Really not how it's supposed to work.
As is being pointed out, in our case in chief, we did try to formally call him back. I think we addressed it with the court, and we were not allowed because he had been listening to testimony, and we understand that. Why we think...
So the judge already didn't let him call him back in their case in chief, but they're trying again now in rebuttal because of evidence elicited by the defense that made him relevant to come and rebut that evidence from the defense, which is exactly what rebuttal is for. But whether or not this fits into that box, we'll talk about that.
It's different, and why it would be unusual, Judge, is first of all, we looked at Idaho Rule of Evidence 615. It says, at a party's request, the court may order witnesses excluded so that they cannot hear other witnesses' testimony, or the court may do so on its own. But the court has full discretion to decide what to do in this instance. Then I would further just point to the court to a rule I don't often hear cited in legal proceedings, but it's nonetheless there, Rule 102 of the Idaho Rules of Evidence. Stands for the very basic proposition that these rules should be construed so as to administer every proceeding fairly, eliminate unjustifiable expense and delay, and promote the development of evidence law to the end of ascertaining the truth and securing just determination.
That is in the interest of justice, basically. Everything can be decided and basically overridden in the interest of justice. This is the justice system. We want the right and true result, but we have rules, and everybody has to play by the rules, or it's not a just and fair result.
State's position is that, particularly with that first point, it simply is not true that Deputy Cannon was showed any pictures of a paintball gun on a computer screen. And frankly, on the second point, Your Honor, Deputy Cannon his character's been attacked. He's been called a liar. And so we feel like in the interest of trying to ascertain the truth and to secure just determination on these very narrow issues that we should be allowed to call Deputy Cannon. I will note to the court, I did go back and look at an October 9th report from Deputy Cannon and then a further subsequent report of an interview of Deputy Cannon by the AG's office. And there's nothing in there that contradicts what he might testify to. Frankly, if it never happened, there'd be no reason to see any reference in the report that he was showing any pictures in a computer screen because it said it never happened. So that's really where we're at, Judge. We understand that there's an issue. He has watched testimony. We do think on these very narrow points that the court should allow us to call him.
All right, just to clarify there, Mr. Wixom in prior testimony, and I'm of course thinking back over it as well, but you said a couple of times he's been called a liar. I don't know that the term he's a liar came out in testimony, did it?
No, I agree. That was just a characterization.
Okay, so there's been a clear contradiction, you could say, in testimony between two witnesses. I wanted to make sure I didn't recall hearing anyone refer to him as a liar other than an argument here. Is that accurate?
He never used that word, Judge, but as I recall, his characterization of Deputy Cannon's version of the facts was that there had been some intentional inaccuracy. I'll leave it at that. But he did not use an inflammatory word like liar. He did not do that.
Okay, thank you. All right, Mr. Pryor, then there's a proposal by the state in their rebuttal.
The state in this case seems really ethical throughout the process. I will just say they don't stretch. They admit when they make a mistake. They try to fix it. They make their arguments. There was a lot more fire and negativity and kind of nastiness in the pretrial phases of this case than during the trial. And I've appreciated kind of how that's gone. And I think maybe that, I don't know, maybe that's part of the lawyer in me and the rule follower and wanting things to be fair. Maybe that's why I think they're doing such a good job and why I've felt like they are proving this case beyond a reasonable doubt. But I don't know. I don't know if that just has a subconscious effect on me, but they've done a really good job. I trust them. They've seemed credible to me. Sometimes that's not the case with, the prosecutors and defense attorneys. Again, sometimes it, cuts both ways. But in this case, maybe it's comparison to prior. I don't know. But that's the feeling I've gotten watching this case. Just like this. He's like, Judge, I'm not trying to hide it. He watched. He's not under the rule. We release him from a subpoena, but we have a legal argument. that we think we should be able to call him, and in the interest of justice, we think we should be able to call him. And then it's up to you, Judge.
Case to call witness Deputy Cannon. You've heard the argument and understand, I'm sure, the issues here, and also that he's also been listened to subsequent testimony. What's the response from the defense on this proposed witness testimony?
Well, Judge, there's a couple of things I'm still a bit confused about. They're going to suggest that at no time, one, that Deputy Coulter viewed a video that was claimed that he viewed. Is that one, Mr. Wixom?
Yeah, I'm not sure that there's a video, but I think the testimony from the witness.
Computer.
Yeah.
It was a Google search of
Google search. Yeah. And two, at no time that Deputy Coulter was inside the home. Is that what the other one?
I believe that what he would say is he had just put his foot into the door and just barely crossed the threshold, but he didn't go inside the home to talk to anybody other than Tammy.
Okay, so Judge, one of my concerns is that we went over his statement at the time of his testimony on cross.
And one other point, there's a second also statement about him talking to, with Joe Murray, and whether he heard a scream. I think that someone said that she screamed or he heard a scream. So that's a separate issue as well that you can address if you'd like. Sorry to interrupt.
And Joe, and Judge, one of the difficulties, Your Honor, is that, in reviewing Officer Coulter's report, the very first sentence of his report, and I quote, "On October 9th, 2019, at 21:40 hours, I was talking to Tamara Daybell in her front room of her home." So for Officer Coulter now to say, well, I only just stepped in. Well, that's not what that's suggesting. The first sentence says he was talking to her. And lo and behold, Judge, that computer is in the front room of the home. And he was there long enough to then identify the fact that Garth and his son, or Garth and Chad, were at the front door leading into the kitchen. The concern I have is this, Judge, is that this witness was called, he was cross-examined, and then there was the ability to recross. And now what's happening is they don't like the tone of what was testified to, and the evidence isn't favorable to them. So what they're going to do is engage throughout this rebuttal in a process of trying to discount everything that we've presented in our case in chief. And they're going to start with Officer Coulter and pick these little things that they can differentiate. And they shouldn't be allowed to do it. That's not what rebuttal is all about. They can challenge.
Well, some could argue that's part of what rebuttal is, but I do agree with him that his report definitely leaves it open to interpretation on who's right, Mr. Murray or him, and how they describe what happened in Tammy's house and where he went and what he did or didn't do or didn't hear and did hear. But the point of the trial is for you to call your witness, get everything you need, the other side to call their witness, get everything they need, and the jury has to find who's more credible if there's two opposing sides. And so many trials, witnesses say, no, that didn't happen, this happened. And the other witness said, that didn't happen, this happened. The officer testified to what he believed happened. Murray testified to what he believed happened. There's no reason to allow the officer then to come up a second time and repeat what he already said, especially when it's contradicted in his report and they've already kind of had the discussion around these points. So I don't even think it's appropriate rebuttal argument, even if we didn't have the rule of sequestration issue. Will the judge agree with me? It's another story.
Challenge evidence, but they've excused this witness. They've excused this witness, and this witness has now been tainted by looking at all of this other evidence, by reviewing all of this other evidence. And Judge, you're right. I never called Deputy Coulter a liar. Did I challenge his accuracy of what he said? Absolutely. That's my job, to challenge witnesses as to what their statements are. And the state had a chance to recross, and they elected not to go forward any further and inquire. And now after the case is over, it's sour grapes. And they don't like what has been presented, and they've got to figure out a way to try to punch holes in any little thing they can. The only problem is this witness has already been tainted. So tainted, Judge, that he's offended by Mr. Wixom's own statement that in some way I've somehow called him a liar. Well, that sounds to me that we don't have a witness who's going to get up there and say, anything that's consistent with his report. What he's going to try to do is prove that he's not a liar. And that's not what this was designed to do. Rebuttal is a whole other purpose. And on the issue of 615, Judge, and excusing witnesses, that's designed when a case starts, and by motion, either party can make a motion to excuse witnesses. That has nothing to do with after the state rests their case. And suddenly they decide that, oops, we shouldn't have released Officer Coulter. And now on second thought, let's bring him back and let's take another crack at the defense's presentation of evidence. I wholly object to this tactic. And if the court opens this door, you're going to open the door to a litany of rebuttal that could go on for days. And it's highly inappropriate.
I thought he was going to say you're going to open the door to now every time a defense witness tells a different story than a state witness, they can call all those witnesses back and repeat the same testimony in rebuttal, which is absolutely not what rebuttal is for. Now, what it is for is they call an insurance agent that discounts some of what the insurance discussion was. They call another person that we're going to watch some together that tells a completely different story that impeaches a defense witness that could be very material that we didn't hear before. So again, that's more of what rebuttal's about than, one state witness saying this, defense witness saying the opposite, and the state witness gets to come back and say again, no, he's lying, not me. That's not really what rebuttal's for.
All right, Mr. Wixom, any responsive argument before I make a ruling here?
Very quickly, Judge. Frankly, Judge, it's certainly not a tactic. Rebuttal is something built into the rules, built into the system. It's part of litigation of a criminal case. With respect to some more specific points, the state can't anticipate when we do release a witness that inaccurate testimony is later going to be offered by the defense. And that's what we think happened, particularly the questioning of Detective Kayakamano. In fact, as I recall, I think it was defense counsel who offered that. No witness did. He offered that in a cross question, this idea of being shown something on a computer screen. We can't anticipate that coming in. And
Well,
so
if the defense attorney just offered it, it's not even in evidence. It's just a question.
certainly not a last minute tactic. What we have is a situation where evidence has came in that our witness was not directly cross-examined on or directly examined on. We couldn't foresee that these kinds of questions would come up because our positions, they simply aren't true. And so we believe that we're simply applying the basic function of rebuttal, which is to consider evidence that's presented by the defense and then responding to it. That's what rebuttal testimony is. I will acknowledge again to the court, I think the fair concern is whether or not his testimony may have been tainted now by the fact that he's listened to more other portions of this case. We don't think he will be. If the court has questions, he's available for questioning by the court on the stand to explore whether or not he's been tainted, and to voir dire him or the defense counsel if the court permits that. So we certainly, we do believe that these are things that need to be addressed. We didn't have a fair chance to address them. That's what rebuttal's for. We don't think he's been tainted. And so we simply ask the court to give us the opportunity.
All right. Well, I'm considering this. I will note a couple of things. First of all, in terms of the propriety or impropriety of calling him in rebuttal, I do agree with the state's argument here that in a case, the state bears the burden. And so it is the state that's allowed an opportunity for rebuttal witnesses to come in and testify. In this instance, there were some narrow topics that came up in the course of the defense case in chief, which are subject to rebuttal, including this issue of whether or not there was, showing of pictures on a Google search in the residence, as was testified to contradictorily between the witnesses, and also comments that the deputy said, including whether someone said they heard a scream. So it's not improper in any way to allow for rebuttal of those statements. The thing the court is weighing a little more cautiously here is whether or not.
So the judge thinks it would be appropriate for rebuttal. Again, disagree there, but it's within the judge's discretion. So if I was the judge and I left it out, I think that'd be fine. If he was the judge and he lets it in, I think that would be fine if that was the only issue. But then we go to the bigger issue, which if the answer is no to this and it's going to be excluded because of what he's about to get to, meaning the fact that he's already watched other testimony and is somewhat tainted, that will become a moot point.
Now, the court should permit the witness to return after the witness has been observing or listening in on the testimony. And the court would note that the exclusionary rule under 615 governs that. It's discretionary with the court. There's a lot of cases out there that say that. State versus Slauson 124, Idaho 753. The granting or denying of a request for exclusion under 615 is a discretionary decision of the trial court. And whatever the remedy is also up to the court in its discretion, according to State versus Christensen 100, Idaho 631. So I don't have any hesitation determining that this would be appropriate rebuttal. The real question then is whether or not the witness testimony has potentially been tainted, where the witness, having been released by the state, observed the trial proceedings, and the witness would be placed under oath and sworn to tell the truth. So I'm not making any speculation that Deputy Coulter Cannon would not just come in and tell the truth, but the observation of that trial testimony on those very points is somewhat concerning, where the court ordered an exclusionary order for the witnesses when this case started because of the manner in which public access has been provided, and the whole case has been live streamed. And essentially, when witnesses are permitted to view and listen to other testimony, whether they do it intentionally or subconsciously, there's certainly an opportunity for a witness to know, exactly what they're going to be asked about, how they would respond to that, think through what some other witness said. And in a typical trial, you just wouldn't be allowing the witness to sit in and watch other witnesses to prepare for additional testimony. So quite honestly, I have vacillated back and forth on this second part of whether or not his observation of the testimony should result in him being excluded from offering this rebuttal testimony. Clearly, the door was opened by the testimony that was given in the defense case in chief. But upon weighing out the discretionary function the court has here and looking at whether or not I think there might be some prejudice that could result from allowing the witness to return and testify after hearing the contradictory testimony does cause me some real concern. And so and I very much appreciate the candor of the state in revealing that Deputy Cannon has listened to the testimony, which further goes to me indicating I think he's clearly and honest in the testimony he's provided at trial in terms of at least what he's testified to under oath and his recollections, as well as notifying by proffer to the state and again to the court that he has in fact heard some of this testimony. So I have no reason to personally question his credibility, but again, the ability to have heard that testimony And even if it's subconsciously just being allowed to prepare for that, I think ultimately is at least an appearance of impropriety or perhaps an unfair advantage a witness would have if they took the stand on those very issues, knowing exactly what somebody else testified to. So the court is going to not permit his testimony in the case in rebuttal on those topics, not because they're improper rebuttal, but because in this particular instance on these particular topics, he was able to know precisely what was testified to. And with a defense objection, I think it is proper that the jury will be just left to consider not which version of the events they do believe. So for that reason, I am going to grant the motion of the defense to exclude the testimony of Deputy Cannon.
So he's out mainly because it's an unfair advantage to watch you're under the rule, you testify, then you get to watch the trial, then you get to come back and kind of fix your testimony after watching the trial. That would open the floodgates, especially with cases that are streamed publicly. So once again, something new, something different, something that's streaming trials live and with public access is changing the way this stuff all works. I think it's a very good and well thought out motion, even if I disagree or order, even if I disagree with parts of it. I like the way Judge Boyce handled this and puts it all out there on the record. I think that was it, but let me just confirm here with the end of his ruling.
So that's going to be the court's ruling on that issue. Mr. Pryor, do you have any questions on that?
No questions, Judge.
Any questions from the state?
No, Your Honor.
Okay, thank you, counsel, for bringing that up to my attention outside the presence of the jurors. At this time, then, we'll go ahead and bring the jurors back in, and then is the state going to have additional rebuttal witnesses today?
Yes, Your Honor, we're prepared to call another witness.
Okay, thank
All right. So let's listen to one of the witnesses that the state puts on the stand here. Young guy comes and takes the stand, and he's got something to say about Tammy Daybell's death and how she was found and how he knows about it. So let's take a listen.
All right, the court will note now the witness has been sworn. Before we begin with direct examination, I'll just inquire, Mr. Beglin, have you listened to any of the testimony that's taken place in this trial, either through the live stream or any other way observed any trial testimony?
I have not. No.
Okay, have you talked to anyone else about anything they've testified to in this trial?
No.
Okay, thank you for those responses. Ms. Blake, you can inquire on direct.
Thank you, Your Honor. Would you please state your name and spell it for the record?
Jason McKay Abeglin. That's JASON MACKAY
And do you go by McKay?
Yes.
Mr. Abeglin, do you know an individual named Garth Daybell?
Yes, I do.
How do you know him?
We work together at a haunted attraction called the Haunted Mill.
And where's the Haunted Mill located?
It's in Teton, Idaho.
And when you say Teton, Idaho, is that the city of Teton?
Yes.
Do you recall approximately?
This guy's a coworker of Garth Daybell, Chad Daybell's son, and he is basically coming to rebut Garth Daybell's testimony about what happened with Tammy when she was found, when she was dead.
When you worked there with Garth?
I started working there, I think, in 2016, and we had worked together for quite a few years. But I worked like right next to him. The year of 2019, we worked, really close.
And when you say you worked right next to him, can you explain a little bit what you mean by that?
He was just one room over from mine, and so if it was slower, we could like talk to each other and stuff. So.
And with the Haunted Mill, typically how long is that open? Is it a seasonal attraction?
Yep, it's open for roughly the month of October.
And so in October of 2019.
By the way, as we're listening, if you didn't know this, this was the most asked about rebuttal witness from any witness the state called in rebuttal so far, or any witness the defense finished with on this day. This guy. Clips were sent to me. People were asking how big of a deal this is. What does this mean? So that's why we're going to watch his entire testimony, which is rather short.
19, you were working in close proximity to Garth.
Yes.
At some point, did you and Garth develop a friendship?
Yeah, we did.
Did you sometimes hang out outside of work?
We went to a few haunted houses together after the season had ended. Yeah.
Did you hang out when you were at work?
It turns out I think that was like one night. So definitely seems like this guy's trying to make it seem like they were a little closer than they were. Not that that matters, because it's all about one conversation. His testimony really comes down to one conversation.
And associate with each other?
Yes.
Did Garth generally talk to you about any issues within his family?
Nope.
Do you recall an occasion when he did share something with you about some family issues?
He told me it was the following weekend after his mom's passing. He talked about that.
What do you recall him telling you about that?
I remember he said that he found her when he got home from work, and he didn't know where his father was. And I don't remember if he said that she was in the bed or next to the bed, but she said she was kind of pale and her lips were blue.
All right, we're going to back it up and listen to that one more time, because that's the impeaching part of the testimony. Garth came home from work, found his mom in bed. She had passed a while before because she was pale, blue lips, and he did not know where his dad was. Meaning his dad didn't get up, didn't yell for Garth to come help me. Tammy didn't roll out of bed while Chad was sleeping next to her. He didn't hear Chad snoring. All of those things that indicated that she passed in the middle of the night while Chad was sleeping that Garth testified to, he's coming back and rebutting, giving the jury another story to consider. Is Garth lying? Is he lying for Chad? Is he credible? That's something the jury's going to have to determine now, because this is in direct contradiction to what Garth testified to that gave a lot of credence to Chad's story, that Chad didn't know what happened. This was natural causes while Chad was sleeping. How could he do this to Tammy if he was sleeping? Because we heard about the asphyxia, plastic bag over the head, pillow over the face, could be two people, somebody sitting on somebody's chest in the airways. So how did it happen?
About that.
What do you recall him telling you about that?
I remember he said that he found her when he got home from work, and he didn't know where his father was. And I don't remember if he said that she was in the bed or next to the bed, but she said she was kind of pale and her lips were blue.
On a typical night, when would work end at the Haunted Mill?
We usually left work around 12:30ish. Depending on how busy it was, we would go later. So some nights we'd go until like 1 or 1:30.
And your understanding from what Garth told you was when he got home, he found his mother.
Yeah.
And at that time, her lips were blue and she was pale,
Yes,
and that he did not know where his father was.
correct.
I have no further questions.
All right.
So they usually get off around 12:30 or a little bit later. I'm not really sure how that fits in with the timeline. I think that actually doesn't fit perfectly with the timeline. But let's hear John Pryor's cross.
Sir, what was the work schedule at the Haunted Mill?
We would open around 7:30 and then it would go to midnight, but we weren't able to leave until the rest of the customers made it through the attraction.
And what days of the week would the Haunted Mill be open during the month, just the month of October, correct?
Correct. And it would be open. They changed their schedule. I think the last 2 weeks of the month, it was full time. And then the rest of the month, it was just on the weekends.
So if I understand correctly, that the last 2 weeks of October would be every day?
Yes,
Did that include Sundays?
No.
So it was Monday through Friday or Monday through Saturday?
Monday through Saturday.
And the day that the Haunted Mill would close would be the 31st of October,
Correct.
Halloween.
Mhm.
Okay. And do you know the day that Tammy Daybell died?
I do not.
Okay. So when you told
He doesn't even know the day Tammy Daybell died, which I think is interesting because he remembers so vividly that it was a week later that Garth came and told him this. Chipping away at his credibility, but regardless, this is something for the jury to consider. If they were like, wow, why did Garth say that? Or if some of them already found or thought that Garth was not credible, this would add into it and basically confirm confirmation bias, basically what they already believe.
the prosecuting attorney that it was the week after her passing, if you don't know what day she died, how do you know it was a week after her passing?
Good point.
Garth he took a day off after it happened and then he was back the following weekend. So it's just when I saw him next.
Okay. So it was the following weekend after the date that Tammy allegedly passed away.
Correct.
Did he mention anything about attending funeral services or any memorials the following weekend?
No, he did not.
Did he say anything about having to do visits with his church or anything like that as part of any program the weekend after that?
No, he did not.
Okay. So he indicated that she had blue lips and she had already passed. Is that right?
Correct.
Did he indicate to you that at that time he played video games until 3 o'clock in the afternoon?
Objection, Your Honor, misstates testimony.
Overruled.
Did he say anything to you about the
So again, this is him kind of talking about how the timeline doesn't match up and trying to throw some darts and chip away that, this doesn't actually make sense. He's must be making this up or misunderstanding what Garth actually said, because it was pretty similar. Like I saw my mom pass, fell out of the bed, but the whole right when I came home from work and I didn't know where my dad was were the important points. And I think John Pryor is trying to say this guy's just kind of throwing details in there that may or may not be true.
fact that he was playing video games until 3 o'clock that evening? Sir,
No, he did not.
did he say anything about hearing snoring coming from the room that night as well, sir?
No, he did not.
And you and Garth would be such close friends. You went to 2 haunted houses in 3 years.
Objection, Your Honor, misstates the testimony. Argumentative.
Sustained.
Move to strike.
I'll strike that question.
So how many, you mentioned that you went to a couple of haunted houses. Is that right, sir?
Yeah, we did that all on the same night.
The same night as what?
It was, I think, the following weekend after our attraction had closed. We just went and visited some other places that were still open.
On the 31st. Who went with you?
It was myself, Garth, Kara Briggs, and Emma Moss.
And this revelation that he supposedly made to you occurred,
Honor, argumentative. Move to strike.
Sustained.
and this statement that he made to you supposedly occurred when during this visit?
Objection, Your Honor. Again, argumentative with the word supposedly. Move to strike.
I'll sustain that as well, Mr. Pryor.
Can you tell me when and time, date the statement was made to you, sir?
I was still at work at the haunted mill. There were a few other scare actors around us at the time. It was a little bit closer to the end of the shift. Garth was pretty quiet most of the night, and then I kind of went up to him and gave him my condolences, and then that's when he told me that he had found her.
So you weren't particularly close friends. Would that be fair?
Yeah, more like close coworkers.
Okay. And this close,
More like close coworkers again. Some of this makes me, but it did its job, I think, for the state. I don't think this was a huge witness. I think there are parts that are big and could be big depending on how the jury looks at it. Generally speaking, I don't think he was an overly strong witness for the state. Seems like a lot of you guys did. So let me know in the comments if you disagree, because a ton of you sent me his clips or questions about his testimony.
coworker disclosed to you something very personal about his mother's death. Is that right?
Objection, Your Honor, calls for speculation.
Overruled.
This close coworker decided on one day just to disclose a very personal matter about his mother's death to you. Is that right?
Correct.
And nothing else, Judge. Thank you.
All right. Ms. Blake, redirect.
Mr. Bagelin, when Garth talked to you about finding his mother, how did he appear?
He did seem sad. So I could tell something was affecting him.
And was he clear to you in his statement that he's the one that found his mom?
Yes.
And was he clear in his statement that his dad wasn't there?
Yes.
I have no further questions.
All right. That will conclude the testimony then of Mr. Bagelin. I don't know if he was here under subpoena from the state, but if so, can he be released, Ms. Blake?
Yes, Your Honor.
So that's it from him. And that was, I believe, either he was the last witness or maybe there was one more. No, I think there was one more law enforcement witness on rebuttal for Friday, May 24th. And then they ended the day early, which was their plan, but the state is not done with their rebuttal. So as far as what's next, they're coming back to court on Tuesday. I'm sorry, that was Thursday. That was Thursday. I think they took Friday off. I'm getting my dates confused with all these trials going on at once. Regardless, no court on Monday, obviously, because of the holiday. They're coming back on Tuesday for more state rebuttal witnesses. Then we have to get through and then talking about what's next. So the state rebuttal, I would assume, is going to be done in a day and a half, 2 days, I think is plenty for rebuttal when the defense's case in chief was, I think, less than a week of total time. I don't think they should get another week of rebuttal or 2 weeks of rebuttal if they're really trying to rebut what the defense put forth. So I would think it would end Tuesday at the latest Wednesday. The court's going to want to go through jury instructions. That can take up to a half a day. So maybe either Wednesday morning or the entirety of the day Wednesday, which then leads us to closing arguments, either Wednesday afternoon or Thursday morning. And then the case goes to the jury. If it goes to the jury Thursday morning, I kind of expect a verdict by Friday afternoon. 2 days, I think, is going to be enough time for the jury to get through this case. We'll talk about where we think the verdict's going. We'll take votes. We'll discuss all that in the upcoming week. There's only 1 day of the Karen Reed trial, so I'm going to be focusing a lot on Chad Daybell. So we could potentially have a verdict by next Friday. At the very latest, that first week of June, I think we'll absolutely have a verdict in this case. But it's not over if he's convicted. If he's not guilty, it's over. If he's convicted, we roll right into the penalty phase. I don't know if Boyce is going to take a day or a short break in there at some point, but the penalty phase is a whole other trial where the state's trying to prove aggravating factors, multiple deaths, particularly heinous or gruesome. Those types of things are going to prove all that up as the factors that make this a situation that's appropriate for the death penalty for Chad Daybell. John Pryor is going to try to prove mitigating factors or that those aggravating factors don't rise to the level for the death penalty. And the jury is going to determine if Chad Daybell is convicted, whether or not his sentence is going to be life in prison or the death penalty. And if he's convicted, we're going to get to watch that live stream, dive into very different details and see how it's argued differently than the guilt phase and all the facts and everything like that. And when they're putting it in front of the jury that it is a legal fact now that Chad Daybell did in fact commit these crimes, if he's convicted, of course. So we'll probably save a lot of questions on the penalty phase to see until we figure out whether or not he's going to be convicted. We're going to focus on state's rebuttal, jury instructions, maybe, definitely do a video on closing arguments, and then hopefully be able to live stream the verdict. I do have a vacation planned at the end of next week, but if the verdict is happening, we will try to live stream it from wherever we may be. So let me know what questions you have. Definitely tell me your feelings on the case at this point. Please hit that like button. Don't forget to do that. And subscribe to our page. Hit the reminder bell so you don't miss any future videos. But that's all we got. The defense is done. No more evidence put on by the defense, and the state is getting close to being done to presenting all of their evidence in rebuttal. And this case is coming to a close very soon. And I'm out of here. Till next time. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.